Good morning. The time being 10 o'clock, I am going to call to order the subcommittee on education, training, etc., of the Special Committee on the Family Court. And welcome all of you here. And looking out there, my guess is that I would like to begin by calling on my good friend, the Chief of Family Court. Is that right? That's not the right title. Or do you have other people you would like me to hear from first? No, it's up to you because it's the court that we care about. And we want you to tell us. I'm sorry, someone seems to be taking offense from what I said, and so I just wanted to make sure I stopped for a moment. I want you to tell us what we can do for you. Terrific. Any way that you want to do it, just remember to turn on the microphone, and you have to speak, as you well know, as if it's your favorite toy.
Okay, my name is David King. I'm the administrative judge of the New Hampshire Circuit. Please follow me.
Yes, my last name Kulp, K-U-L-P as in popcorn.
And your position?
The Senior Circuit Court Administrator.
Thank you.
And Heather is with me this morning mainly because she is sort of the go-to person in the circuit court for all things training, both on the judicial side and on the staff side. So to the extent there are questions about those issues, I would be remiss not to have Heather seated beside me. So I'm not sure how you want us to proceed, Madam Chairman. I'm happy to do whatever you would like. I know you sent us some questions. Some I can answer, some I probably can't.
I did send you questions. I have copies of that if anybody in the room is not aware of what those questions were. Well, that's okay. But I look forward to you proceeding as you wish. I want to repeat that this is not an adversary proceeding. We're not in a court. It is truly an attempt to see what the judicial branch sees that we might do here to help you best meet the needs of the citizens of the state. That is our goal. Our goal is not to do anything other than that. And so that's why I hope if you're uncomfortable with that, I can ask you direct questions from this. But that is why, if I had my druthers, I would give you completely free rein to share with us what you think would be helpful.
Okay, excellent. So let me just start by sort of talking about, I put the judicial training into, I'm talking just on the judge side now, sort of three buckets. One is the new judge training. Since we created the circuit court in 2011, since the legislature created the circuit court in 2011, we've onboarded more than 50 new judges, which seems hard to believe, but we've trained more than 50 judges since 2011, and we expect to train 10 more this year, which also seems hard to believe. Every new judge that comes to us comes through the governor and council process. As you well know, we don't pick them. We don't pick their skill set. We don't pick where they come geographically or what they bring to the table. But we, having done this for a number of years with a lot of judges, have figured out a way to try to tailor the training and the resources that we have to the new judges as they come on board. So if we have, for example, some prosecutors, chances are they have trial skills because they've been trying cases in the circuit court. They know the rules of evidence. They know the cadence of a trial, but they probably know nothing about the family division at all. And so we would tailor the training with those new judges more heavily on family and lighter on criminal. It's more difficult when we have sort of a blending of talents and we have to teach everything. It's like you have to kind of teach to the bottom of the class for all of the new judges. We also have the issue of ongoing training for the circuit court judges that we do on a regular basis with our own in-house resources. We have 5 judicial trainings a year that we put on that are mandatory for all of our judges. And then the third bucket is what I call the specialty training. And the example I use is the probate training, which is kind of a nuanced area of the law. We really haven't had appointments to the circuit court with new judges who have had much exposure to probate at all, except for 2 of our staff attorneys who went from the probate division staff attorney position to a judicial position, which is great. And they're both doing probate dockets now. But again, that's a sort of a really specialized area of the law. That's where I came from. I was appointed to the probate court 34 years ago this month by Governor Gregg, and I'm the only probate judge left in the state, and I'm trying to build a bench of probate judges to come behind me. So that's a challenge because we have to do it on an ongoing basis. So I think I'll have Heather explain the funding sources that we currently have in terms of where we can get monies, where we can send judges, and an overview of what we do in-house for the new judge training, which Heather has put together over the last few years.
And we certainly welcome questions as we go along, so please don't let something said go unquestioned if you have additional questions about that. So focusing exclusively on judicial education and funding sources that we have available. So thankfully, we've been able to use a few grants, at least in part, to fund some of our judicial education programs, particularly for current judges to attend trainings. We try to send new judges to domestic violence training at a national level when they join the bench. COVID prevented that from happening for a few years, and so thankfully, using VAWA funds, Violence Against Women Act funds, that the state is allocated every year, and a portion of that does go to the judicial branch. We were able to actually bring those trainers that we would normally send people to New Hampshire this past year. And so we were able to provide training to the 20 judges who hadn't been able to attend that training yet, and also include a full day of training for all of our circuit court judges on dynamics of domestic violence, including dynamics of domestic violence as they relate to divorce and parenting cases. And so that was a real advantage of being able to have some grant funds to be able to use for judicial education. Another source of grant funds, once again, the state is allocated a portion of access and visitation funds every year, which are allocated to DHHS. There's an RFP process for that we generally apply for. Access and visitation funds are intended to provide resources to parents seeking parenting time when there's a child support order. So that's used in a variety of ways. From DHHS chooses a variety of ways to use those funds, but one of those ways is to fund mediation for indigent parties who have parenting matters and also a child support order, or are seeking to create a child support order. So we're able to fund some mediation training, both for mediators, but also some training for judges and for court staff around skills related to facilitating parenting plans, facilitating the creation or maintenance of child support orders, from that fund. This year, we were able to use some of those funds to create some videos that will be forthcoming. And thanks to this committee who made recommendations, I think in a former iteration of this committee, made some recommendations that we include more videos on our website, particularly for parenting issues. So we did create a video about how to create parenting plans and how to create child support, how to complete a child support form. So we're able to use those funds for training, but also for ongoing training for judges, but also ongoing training for some of our staff and mediators. I'm getting a bit afield into the staff bucket, but but I think it's helpful to note how we use those funds.
Thank you. Is that training, or are those videos available to the public also, or is it
They're not
focused
yet
on
currently.
on the court staff?
They're not yet currently available to the
Okay, thank
public,
you for
but they will be. Yes, they were intended to be created for the public. Often the staff will use those for their own education and also use those with members of the public with whom they meet. Our staff are often meeting with self-represented litigants to assist them with those forums, so it's a great training tool for both staff and litigants. Representative Pearson?
Thank you, Madam Chairman, and thank you, Counselor. Unless I've cut you off in your presentation, I'm not hearing any money is coming from the general budget to the judicial system. It's grants and it's sliding over from DHHS. Since I'm already anticipating talking about the next budget
Okay.
for the judiciary, this will be helpful.
So I can talk about that in general terms, and we have always had an education line in our budget going back to, I want to say maybe 2007, when the chair of House Finance is now in this room. And we were in the Lynch sort of leaning years. We cut our education line dramatically. I think it's now around $90,000, which covers education for all three levels of court. There's a separate amount for IT folks under Supreme Court Rule 45. That, in theory, is managed by what we used to call JBEC, the Judicial Branch Education Committee. It was chaired by Justice Conboy for a number of years. I was on it for probably a dozen years. That's kind of gone by the wayside, but the line item is still there, and Aaron may have some more specifics about how it can be spent, but we can ask to spend that money, as can the Superior Court and the Supreme Court. There's no specific allocation anymore about X amount for each court, but there are some general funds available for judicial education in that fund, in that line item.
Your Honor, it's possible that your colleague has something to add to that.
Oh, good, Nancy. Excellent. I'll give her the chair.
Hello. Nice to see a few of you twice in a row. Diane Martin, Director of the Administrative Office of the Courts. The Chief Justice asked me to come over in case you had questions about the general fund budget or specifics around amounts spent and that kind of thing. So I have that. It sounds like you're interested in it. Judge King has been here forever and obviously has a lot of knowledge about the history, and he was really close to the exact number, which is $94,500 is the total amount for general training in the courts. It's used for all employees. We have about 800 and judges. And as you heard from Senior Administrator Culp and Judge King, there are other sources of funds for training. Those are generally grants. And so I have ballpark numbers on that as well. But
Excuse me, do you have
94,500.
that to hand out to us?
I don't. I actually just got the grants unit to give me a report, asked for it this morning after the chief asked me to head over with that information. So I can give you the numbers that I have. But 94,500 divided between AOC, Circuit Court, Superior Court, Supreme to do all of the training that's generally funded.
In other words, not much.
Not much. I did the number. It was about $118 per employee. And some of the judge training, for example, Superior Court sends new judges to a training in Nevada. The cost for that has gone up because travel and all of that is more expensive now. So the average is about $6,000 per judge. So if we send 6 judges, that's $36,000 right there. In addition to that, as Judge King was just saying, there's another bucket that is e-court specific, and that is used for all parts of the judicial branch to go to trainings related to that. And so folks from Circuit Court, Superior, AOC, IT people go to a training that's usually annual related to e-court. And so that's where those funds generally go. And then drug court has a separate allocation that the legislature that is specifically requested for that. It's not actually generally used for our employees, except for those directly involved. It's more used for the drug courts themselves, the people who run those drug courts, to get training to do that well. So they're not necessarily our employees. They are people that we contract with.
Is that report something that you would be willing to share with us?
I can get you the numbers. She's literally putting it together, but the totals.
So in other words, what you have there isn't something that you could
No,
share?
this is just I pulled my because I could quickly do this myself. The appropriations that we have
I
and
see.
how they're
Okay, 'cause
divided.
I was going to ask,
I can give you this though.
yeah,
If
if you
that's
could,
helpful.
that would be great. I was actually going to see if Representative Pearson might be willing to walk down the hall to the finance office and get copies for us. If I ask nicely. That is so kind of you. I appreciate it. And I know also that close family members appreciate it too.
He's been like a son to me for,
Just, yeah. Thank you
what-
so much.
What that will tell you really is how the legislature has what they've given us in total and how it's divided without much other detail. The quick numbers I got were so far this year from the general fund, about 31,000 has been expended. That's not necessarily from this appropriation. It's probably a crossover between the two, but since the start of the fiscal year, and then from grants, including, and you have to understand this includes conferences and trainings and trainers coming into us, something along the lines of 85,000 in FY23 for just
Thank
circuit
you.
court.
Thank you for taking the time to pull that up for us. It's very helpful.
You are welcome.
Does anybody else have any questions about that? Could we go back to my old friend?
okay, that's twice has been an ageist reference. Are you anticipating with great delight a bill that we may pass and the governor might sign that extends the age from 70 to 75?
Am I anticipating it?
Yeah.
You don't have to answer that question. It's not relevant to the subject. And
I'm
old
sorry.
refers not to the judges or my age. I would lose in that. It refers to the fact that we have worked together on these issues for 20 years or more. Oh, wait a minute. More than 20 years. So that's what the old refers to. Is that fair?
That's fair.
I stood
Okay, the judge
corrected.
doesn't want to overrule that.
No.
Okay,
I
go
won't
on.
Say that it was 40 years ago that I was a member of the legislature either, because that seems like an awful long time ago.
And by the way, I also worked with the judge's father. Quite happily.
I'll shut my mic off.
So that's great. Diane's given us a sort of a breakdown of the general funds. I also understand, Aaron explained to me this morning that there's a bill that would provide for a trainer, and that all sounds great too. I think in terms of training the circuit court judges, there is always a benefit to sending judges to these out-of-state programs. They're excellent. I've never gone to an out-of-state program where I didn't come back feeling energized and having learned a lot. But our focus on the new judges really has to be on substantive law for New Hampshire, because the circuit court is a court of limited jurisdiction. We have only the jurisdiction that you give us, but it's huge. You know, I say the Superior Court has civil cases and criminal cases. We have civil cases and criminal cases, but then we have landlord-tenant, we have abuse, neglect, we have guardianship, and all these case types that have nuanced legal issues that we really have to train on. And because we have 34 locations around the state, and most of them are what I would consider to be small courts, we don't have judges who can be specialists. The judges really have to be able to do pretty much everything with the exception of probate. We've cut that off to just a few judges. Only in the Nashwas, Manchester, maybe Concord can we have judges who are doing primarily one case type, because the dockets are large enough for that. And there aren't many judges that have the appetite to do only family. Even if they come on the bench thinking, all I want to do is family, it doesn't take long to burn them out to the point where they has to get a criminal docket once in a while too. So I think we do as good a job as we can do with the in-house resources that we have on our judicial training. As I said, we've trained over 50 judges. It's a 6-week basic curriculum that involves some self-study. It involves, I'll use the word classroom, but it's, a conference room, linking up with senior judges, doing court observation. At the end of the 6 weeks, we need to cut them loose and get them on the bench to start hearing cases, and that's kind of what we do. And then we have a lot of tools that I've explained to this committee before that are ongoing that judges can use as resources. We have also talked, I think, in this committee about, and I know, Madam Chairman, you were on the Judicial Performance Evaluation Committee with me and with Justice Conboy for it seemed like a long time. And one of the things we talked about was the judicial evaluation process to include maybe a retired judge who goes and observes judges in the courtroom, sort of mentors new judges. I would love to be able to put something like that together. The difficulty that we have is we have currently 14 judges who are over the age of 70 who are willing to work, and they all have full dockets, as full a docket as they can take, because we need them right now. So as we continue to build the judicial resources and add judges, hopefully some of those more senior judges who still have a lot of good years in them could be used in other ways that don't require their orders to be co-signed, for example. And I think there's a place for that in the sort of ongoing judicial education, if you will. But I think Heather can maybe give you just an overview of what the 6 weeks consists of, so you have a sense of what we try to do with our brand new judges who are coming in from practice, if that would be helpful.
So for us, the first week is really about orienting the judges to the role of being a judge. We know the transition between being a lawyer in practice, sometimes not specifically in practice, but in some other role that uses their legal skills, to being a judge is a fairly large leap. And so we focus that first week really on the role of a judge, orienting them to circuit court, orienting them to other tasks that they'll be taking on, as well as the communities that they serve. So we currently do work with them around trauma, implicit bias, ethics. Judge King spends about a half a day on judicial ethics with them as well. Mental health, ADA access, language access. So areas that are not substantive areas of law, but areas that they really need to know as a framework for the rest of the work that they'll be doing in the circuit court. We have about 2 weeks of what I would consider family division training. So about one of those weeks is divorce parenting and minor guardianship. We do about 2 days of domestic violence and stalking, and about 4 days of abuse and neglect and other juvenile matters. So termination of parental rights, juvenile delinquency, CHINs, etc. So a little over 1/3 of the training is related to family division cases specifically. And then the rest of the weeks are related to our other case types that they'll be handling. We really try to weave different pedagogical methods into that training. So it's not just sitting in a classroom and listening to someone lecture. We have preparatory work that they do, observational work that they do, working with the expert judges, as well as with staff attorneys, court administrators, our DV program manager, our e-court specialist. So we weave many staff into that training as well as judges, and external presenters as well.
And we do it at no cost, essentially. I think we have had NAMI come in and with some lived experience folks, and we've given a small stipend to them. But other than that, it's in-house. It's taking experienced judges off the bench, out of dockets to come in and do the training, or using, as Heather said, our staff attorneys, our in-house resources.
But let me just question, when you say at no cost, isn't it really of some cost? Because my understanding is there's no real free time that you're trying to fill, that by staff and judges doing this, they're not doing other things that they're responsible for.
Valid point. I mean, there's, I guess in economics would be the opportunity cost, right? The cost of taking a judge off the bench and canceling a docket for a day to bring a Judge Lemire in to do the marital training is a day of marital cases that aren't getting heard in Brentwood. When we bring the criminal judges in, it's the same thing. So yes, for sure, using our in-house resources is taking judges off the bench and causing delays in getting cases heard and orders out. And at the same time, when we do our 5 trainings a year that are mandatory for judges, that's a day pretty much that we're not doing hearings. We have to do all the emergencies that day. We have various ways of dealing with that. Typically, we have an arraignment judge or 2 that skips the training and stays behind, hopefully a retired judge. That's what we try to find, a retired judge that's under 70 that can do the arraignments without co-signing. But the judges bring their laptops, and the clerks are instructed at, certain breaks in the day, the DVs, the ex parte maritals, the stalking petitions that have to be ruled on, pretty much in real time. We have to deal with those. So it's not a seamless day where we have training every single minute, but that's how we've managed to get those 5 days in.
Thank you. I have heard from you and observed the court's efforts to use modern technology. For me, modern technology is giving up the abacus, but really modern technology, in hopes that might be time and cost efficient. And some of that involves having the potential, I'm going to use the word plaintiff. Since I'm a non-lawyer, I can use it in a very, very general sense, but I think you know what I mean. The citizen who comes in and sees a machine and has no idea about how to use that machine. And also staff that has to then help the people use. So do you have specific training as you begin to include in your arsenal information technology tools to help both the citizen and the court professional know how to use those tools?
So I'm not sure I understand the question, but one of the
Oh, that's because it was not stated clearly, but
no,
that's okay.
it's because I didn't grasp it. But one of the challenges for sure with self-represented litigants is navigating the e-filed cases that we have, the electronic filed cases. And when we went down that route in 2013 with small claims, we thought it was going to make things easier and take less staff. And what we've learned over time is it's more complicated for some folks, and it definitely takes at least as much time on the staff end. Staff spend a lot of time. Our information center spends a lot of time with folks. Information center that we started in 2013, just by way of a quick fact, they took their 5 millionth call this summer, which I'm pretty proud of. They take about 500,000 calls a year.
Yeah, closer to 400,000, a little over 400,000.
So we have some court navigators. We have 2 court navigators, which are individuals who are trained to work with self-represented folks in the lobbies of courthouses to help them navigate whatever their legal problem is. The bulk of those are ironically probate-related issues, because the probate process is also an electronic filed process now, and is not intuitive for self-represented folks who are trying to navigate the probate process, having lost a loved one. That's something that we are certainly hoping to expand over time. The electronic tool is great in terms of eliminating the paper, but it's a process on our end.
Question to that.
No,
Could we just wait one moment, please? My colleague has a question.
Yes, thank you, Madam Chair, and thank you, Judge. What if, let's say, here's a hypothetical, a pro se person comes and freaks out at the machine? Does that person have the right to say, can I bypass that and do it the old-fashioned way?
absolutely. There is an exception, request for exception for electronic filing that I've never denied one of those. We have a lot of people who don't have computers, who aren't computer literate, who just want to file in paper. That's absolutely fine. They file in paper, we scan it in, and rather than send their court notices and orders electronically, we send them by first class mail, the old fashioned way.
Thank you.
With your permission, I'd like to just add a little more information about the other resources, and these are new. So we did receive from the governor's office and the legislature approved ARPA funds to be used for access. And so our Office of Access and Community Engagement, which applies to the whole branch, has 6 projects that are ARPA funded, which address some of the issues that you're raising. And so I didn't want to not mention them. One of them, and I'm not the expert, I wish that our deputy was here. She could tell you all the details, but one of them is Community Navigators, which will train a number of people to be available to help pro se litigants. There are 2 projects that I think would be of interest to you. The other one is similarly going to have a number of people trained who will be available not only on site, but also remotely, and available to go out into the community and support people in filing, obviously in a safe public place. But those are projects that are commencing now. We've done RFPs, have vendors to work with them. And so our goal is to provide better access to justice through some of those projects.
Thank you very much. And does that apply to, well, I wasn't going to say, not, I imagine not to the Supremes, but to the other courts, Superior and Circuit?
I mean, technically it will apply to all of them, including Supreme. So if you had a litigant who was doing a pro se filing and needed assistance, they will be available to all litigants, but are focused on pro se litigants. And I think Circuit Court is the most likely court to have those, and the people who are most in need.
And that is that recognition of that is something that the Chief Justice shares.
Absolutely.
Great. Thank you. Another question from Chairman Pierce.
Thank you, Madam Chair, and thank you, Your Honor and Counselor. I was a volunteer firefighter. I have a son who's a fire lieutenant in Manchester. And so I have been well educated in PTSD issues. I recently had a conversation with the Chief Justice on this, that given many of the people who appeared during the 14 hours the Special Committee on the Family Division of the Circuit Court took public testimony, there were statements of judicial bias. And I know from my experiences that even if one is not intentionally leaning one way, life circumstances may tilt one a certain way. One of my day jobs is part-time CEO of a medical facility, and I shadow the new hires because the 9 o'clock appointment just happens to have a disease that killed this new gal's grandmother. And then the 9:30 appointment was something that her husband worries about. And by the end of the day, she's seen loved ones in the persons of several people. And what is she going to do, this new hire? She's either going to become cold and professional as a defense mechanism, or go home and cry or drink, or both. And yet, tomorrow we start a new day. And so I have been able to debrief the new hires as to what did you feel when you saw. And the conversation I was honored to have with the Chief Justice was, if you are in family court and you hear all of these things day by day by day, and just every so often one of those cases triggers something in you of an experience or in a loved one, what are you going to do with that? And it would be something, because I know of his interest in mental health court issues, that could be explored in ongoing training, especially in family court. How is the cumulative effect of being on the bench in family court for week upon week impacting you, perhaps in ways you're not aware of? That would be just a pitch for further exploration.
Yeah, and I would add to that that it's not just the judges, it's the staff, because they're dealing with these
Yes.
folks at the window and they're typing in the dictation center the judge's orders. And I have had staff members come to me in tears. You know, the judges follow a family in an abuse neglect case that has maybe an opioid issue, and the judge thinks things are going in the right direction. They've been clean for a while, and all of a sudden, you know, a judge called me on a Sunday night, and somebody that they thought was better overdoses and dies, and the judge is blaming himself, and the staff person who typed that order has been following this family because they've been typing the orders, and now they're typing the order where the person's overdosed, and it's taking a toll on them too. So
My apologies to the staff. I wish to include them. Yes, very much.
yeah, so I mean, we clearly can do a better job. We have done trainings around that for both judges and staffs, but we always can do a better job providing those resources. And the chief has been very supportive. We have a mental health person in the AOC now who's great, who's a resource for staff and judges when we have these kinds of issues come up. So, but it's a real issue. Thank you for that.
And we do include in new judge orientation and fairly regularly connections to resources to support judges around that issue, including the Employee Assistance Program, which I know this legislature has continued to support and has been an incredible resource for us. And so that's a resource that we continue to refer both judges and staff to.
And do you have any way of knowing if they take advantage of those resources?
So the mental health and wellness coordinator has done some tracking around that. We know because of our own personal referrals of staff and judges to that it is utilized and utilized both individually and collectively. Some of the trauma experienced is collective in a court where all the staff and judges are handling the same issues. And so EAP has been gracious to be able to come in and support a full panoply of an office or a department that's dealing with an issue. But there's always more we can do and always more resources that we can provide our folks.
Thank you. What else?
I think I touched on this earlier, and it has come up in previous meetings before this committee, but in terms of the perception that judges aren't writing thorough orders or it's taking a long time to get orders out, I just remind the committee that the circuit court does not have law clerks. We have 3 staff attorneys for 61 or 62 judicial officers, which doesn't go as far as we would like. We tend to use the staff attorneys in the more complex cases. There's a staff attorney who assists Judge Lemire in some of the complex marital cases. I have a 3-day trial next week in a trust case that has 10 lawyers. I'm going to bring a staff attorney with me for that trial because it involves a novel issue that the Supreme Court recently looked at that is probably a fair chance this case will go up. But that's one case out of a huge number of cases. And that's one area where I think both in terms of the quality of writing, because you all visited courts and you can see the pace of the hearings during the day, and each of those cases required the judge to write an order at some point. Without assistance, if there were more of those types of resources, I think the orders would be perhaps more thorough and would get out more timely. That's just a suggestion.
Yes.
Thank you, Madam Chairman. Thank you, Your Honor. Thank you, Counsel. I recall early on when the special committee got going, reference was made to a recent report that analyzed need not on the basis of numbers of cases, but on the amount of time spent, which is probably a better metric. Could I or we have a copy of that? Because while last time I followed you after you made a great pitch for the budget, I came in after that. I want to get in there first and make my pitch for next time. And I've already got law clerks on my list. Could we, or I at least, have a copy of that report?
So just, I want to make sure I know what you're asking about. You're talking about the weighted caseload study that we had done
Yes.
by the National Center?
Yes.
Yes, of course. We can get you that. Would you like it electronically or would you like a paper copy? We can get copies for the whole committee if,
Oh, I like paper, but I can't speak for anybody who is active in this century.
Of course, Representative Kokoto.
Thank you. Thank you, Madam Chairwoman. I would appreciate an electronic one, just so if we need to email it or share it, especially if we're going to be trying to make pitches, we might have to email it to other representatives, if that's
Okay,
possible.
of course.
Thank you.
We'll do both.
Thank you.
What that will demonstrate is a couple of things. It was done both on the judge side of the operation and the staff side, both in Superior Court and Circuit Court. I think the number of full-time equivalent judges that are required under the weighted caseload is 67 point something. Today, I think we're at 43 full-time judges. And then we, as I said, we use 14 judges over the age of 70. Still have 3 part-time judges and we have 3 senior active judges. So
Is that counting the new 7 or not?
that's not counting the new 7. That's on the bench today.
Okay, thank you.
We have 4 judges that will be funded as of July 1st. And I'm hopeful that the governor will fill those. We have 2 that have been confirmed that are awaiting their start date, 1 that's been nominated. That gets us to the 45 number, which is where we would be right now. We'll be at 49 with the July 1st judges, but we also have several retirements this year. So it's kind of a revolving door, which is why this training is so important.
Yes, go on.
Thank you for letting me take my question. Thank you for taking my question. The 4 new judges that are for July 1st, which type of judges are those?
Whatever Governor Sununu gives us.
But was it like allocated for certain, were they allocated for like family division or?
No, since July 1st, 2011, all judges have just been appointed to the circuit court, which has 3 divisions. The statute presumes that those judges will be competent in all 3 divisions of the court. And as I said, perhaps before you came in, Representative Kutab, we would love to have judges who are specialists, but because most of our 34 locations are fairly small courts, it just doesn't work that way. And unless you're in a Nashua or a Manchester or maybe Concord, it's hard to have judges who do only one case type because they have to basically keep the dockets moving. So what we hope is we get judges with trial experience because that's the most important thing. And then family division experts would be great because that's the steepest learning curve. We've got former prosecutors who are doing a great job in the family division, but it just took them a long time to get there. It's easier to teach the criminal side of the operation because it's, there's just not as many moving parts.
Representative Lyons.
I just wanted to make a comment just to say that I think it's great that you're the new judges coming in would be well-versed for all courts, because I think that's important. Because what I was hearing when I made my visit to Concord is that a lot of times, when there's an absentee, somebody is out for illness, you have to be able to have some flexibility. I'm a nurse, so I know about how important it is to be flexible. So I think it's great to hear that that's what's going on. So
And I think in your industry, they call it triaging, right? That's what we basically do every day in the court system. And that's a great example because I can get a call on a Sunday night that a judge is going to be out the next day. There's a docket. There's a lot of people that are signed up to be in that court to have their case heard on Monday morning, and we scramble to try to shuffle judges around. Maybe we can find a judge to cover the morning, a different judge to cover the afternoon, but we have to, those cases have to be heard. So we don't have an injured reserve list where we can call a judge and say, hey, a retired judge, and say, can you go to Franklin tomorrow? Because that judge is already booked somewhere else. So I'm hoping we will get to the point where we get closer to that, weighted caseload number where we'll have more flexibility.
I wonder if Belichick's available now. He might have some free time. And I'm
He's going
sure.
to Cincinnati.
Oh, is he?
Yeah.
Oh, I didn't know. I'm sorry. If you have anything else that you want to say about training, that's great. I'd like to hear everything you have. I also do want to go to another one-word title, and that's accountability. And it might not be a word that fits precisely. I mean, it might be a round peg that has to go into a square hole or vice versa. But the basic question is there a process that can hold, short of charging a judge with inappropriate behavior in whatever way, where we can assess in some way the accountability of the judge, where someone is observing what is going on in the courtroom, where someone is particularly sensitive to concerns that might have arisen, and a process for addressing the issue, which might include additional targeted training or consultancy in some way.
Great question. I'll start with the statutory requirement that every judge is evaluated every 3 years through a formal process. And again, that goes back to the Judicial Performance Evaluation Committee that we served on together. And we had Professor Smith from UNH work with us to refine the instrument that we use to do those evaluations. I have, I think, 13 evaluations on my desk from the most recent round that I need to review and then review with the judicial officers. So that's sort of the first line that we have to do, and it's a good tool. But I've been doing this for a while, and I have often said that rarely am I surprised when I get a judge's evaluation, because it's a small state. Lawyers don't hesitate to speak up when they see an issue. We certainly get plenty of complaints from self-represented litigants. And it's very easy for me as the administrative judge, if there's a complaint about a judge, the judge did, pick the atrocity, swore at me, something happened in a hearing. Typically within 30 minutes, I can have the audio from a hearing on my laptop and I can listen to it. And I do that regularly. And if there's an issue, I always pick up the phone and have a chat with the judge. More often than not, I don't agree with the complaint that was made because it goes more to the merits of the case, but that's an ongoing process. I mentioned earlier, I think it would be a great tool for us to have, probably I'm picking this term out of the air, but a court observer who would be a retired judge with experience who could sit in a courtroom, observe a new judge or a judge who may have issues, and spend time with that judge, whether it's a demeanor issue, whether it's a timeliness getting on the bench, whether it's issues with written orders, to sort of be a mentor that we could have 2 or 3 of those available on an ongoing basis, I think would be a wonderful tool. Again, we're limited. Retired judges are limited to the number of days that they can work by statute. There's I think it's RSA 493. Chapter 493, a retired judge is limited by that statute in the number of days they're available to work, and most of those judges max out. It's about 80 days a year that they can work. If that restriction were lifted or changed, we might be able to pick up some judge days even if it was specifically targeted to something like this, that in addition to sitting X number of days, they could be a court observer That would be a wonderful tool for me as an administrative judge to have to say, you know, we've got an issue down in Nashua. Judge Jerry Boyle, who's been retired for a few years but still loves to work. Could you go to Nashua and sit with Judge X for a couple of days and give some positive feedback and report back to me? And I think that would be great.
Is that something that a retired, experienced attorney could do?
Sure, I think that would be a possibility. I think the judge who's been on the other side of the bench, which is really a different world, is probably better situated to do it. But I mean, it could be a layperson that, you know, if it's something that's obvious. But I think in terms of mentoring judges, retired judges are probably the best resource that we could come up with.
And I gathered that the hour restriction has to do with compensation more than anything else.
Correct. I recall when the legislation went through, there was a concern that at the time there were a number of retired judges, and I think the concern maybe legitimately of the legislature was you only need this many judges. Your bench is full, and if we take the governor off this, you'll have way more judges than you reasonably need to move the cases, and it's going to cost a lot of money. That's not the reality for us. We don't have anywhere near enough judges according to the weighted caseload, and that's one of the limitations that we have is that statute. It only costs the state the per diem for the judge. There's no benefits, obviously, because they're retired. Just something to think about.
And in terms of, maybe it's not related here, but in terms of this caseload problem, generally speaking, if you had your choice, and you won't have your choice, we know that, but if you had your choice and you were told that you could bring in a certain number of bodies, would you choose in the next biennium to have more judges, or would you choose to have more support staff? That's a light and frothy question.
Yeah, that's a great question.
Why do people say it's a great question when it's a question that you don't want to answer?
Because I'm trying to think how I'm going to answer it. I'm just trying to say something and to fill the void. I'm going to say a blend would be my choice. Maybe
How judicious of you.
a couple of judges and maybe 3 staff attorneys to support the bench would be, and I'm trying to be conservative in my number. I'm not, and the chief has been great about adding judges, but I think we all agree we can't do it all at once. We have to do it in increments.
I guess my question, which shows how little I know and why I'm sitting here and you're sitting there, is that I would think that one of the most effective changes you could advocate would be for judges to have clerks. Now, this is something, of course, that the Supremes are protected from, and the Superior Court judges are protected from. But if in the Circuit Court, the judge didn't have to do all the work that is usually the responsibility of the judge, but also the work that is usually in other court situations the responsibility of support staff, would that not make a significant change in the ability to manage cases, and both in terms of the number and in terms of the stress? In yesterday's hearing, at some point, someone objected to the fact that judges might have to work in the evening or weekends. And truthfully, I have no sympathy for that argument. Judges are not hired to work a 40-hour week, or I guess it's now 37 and a half hour week. It's a professional job and you're not hired by the hour. So I have no problem with judges agreeing to be judges and then finding they have to work when they might otherwise want to watch, was it Cincinnati? Did you say where Belichick's going?
That's where he's going.
Yeah,
He said
okay.
so.
Okay. No sympathy for that at all. But I do have sympathy for a judge wanting to do the best job of a judge and being hampered by also having to do work that is difficult and complex. I'm not demeaning it in any way, but that could equally, if not better, be done by someone who's a trained clerk.
I think that would be a huge resource, and I think if my colleagues, especially those that sit in the family division, were here, they would say, we call them staff attorneys, but that resource to assist with writing the difficult cases, doing the legal research. And I agree with you, Madam Chairman. We tell new judges, this is not a 9-to-5 job. This is, the circuit court's open 24/7, 365 days a year. Our judges take calls in the middle of the night for domestic violence issues, search warrants, placement of children. You can be on vacation in Florida. If you have a cell phone, you may get a call from someone and you have to deal with it. That's just the nature of the beast. So it's never been a 9-to-5 job. It's never been touted as such. And if a judge thinks that's going to be the case, they shouldn't apply.
Thank you, Chairman Pearson.
Yes, thank you. I face the same thing with my doctors. I think you know, Judge King, I've studied the rules of evidence extensively.
Yes.
And my amendment, which replaced the entire bill of either 475 or 499, states that if a judge refuses to accept a proffered piece of evidence over the objection of a litigant, or if a judge accepts a proffered piece of evidence over the objection of the other litigant, the judge, because of course they did it for very good reasons, their ruling must state that in writing. Is that something the review of that new line on the form saying this is why the judge ruled that way, is that something that could be reviewed by someone with, and I don't mean to disrespect, but lesser training
So
to find patterns?
if that bill requires a written ruling on every objection, I'm going to use the trial I'm going to have next week. I'm going to have 10 lawyers in a courtroom. Do you know how many objections I'm going to have to rule on in the course of 3 days with 10 lawyers in a courtroom? If I have to make a written finding on every one of those objections, that's going to be a 30-day trial, not a 3-day trial. So that's what the Supreme Court is for. If there's an objection, judges are trained to rule on the record. It's overruled. You know, Judge Perkins, who I love dearly, I tried dozens of cases in front of him in the Superior Court, jury trials, bench trials. He would say, you would say objection, and he would say one word. He didn't want to hear an argument. And you would say leading, argumentative, whatever it was, and he would rule up or down. And It
Okay.
would be on the record, and the Supreme Court could
Okay.
review that.
That's what my amendment was seeking to do, not just say, no, I'm not going to accept that, or yes, I am, even though you don't want me to. Here's why, in a word or two, and that will be written. Because a lot of our testimony was the judge refused to accept that piece of evidence and didn't say why, or the judge accepted it and I objected as a pro se litigant and the judge didn't say why, and I think the fix is in. And I tried to maintain the judges don't do that. Judges do it for a reason. And so the fallback was, okay, can it be written in the record?
Yeah, and if it's going to be written and we have to do that, it will dramatically slow down the pace of a trial.
It passed unanimously in the House, so
Okay.
be prepared.
Okay. And when I say dramatically, I mean, again, there are, in the course of a trial, lots of objections. And I don't know if we take a recess, issue a written order, come back, I would expect that's how judges would want to do it so they don't lose track of them.
I think the tenor of the amendment became the bill, which was passed by voice vote, was very simply a word. I offer this piece of evidence. It is not accepted because it is non-probative or whatever. That's quick. It's not a long dissertation. It's one or two words. And that now is in the record, one word, two words.
And I think what was lost on me with in the record, when judges and lawyers think about the record, we think about the record of the hearing. So it's the objection is overruled. It's irrelevant. It's
Okay.
that should, I mean, litigants have the right to understand why you let something in or didn't let it in. That should be clear at the time on the record to the litigants.
And that's all the amendment become bill is asking for, because it will speak to many who were in those 14 hours of testimony that no answer was given. I can't say whether no answer was given or not. I wasn't there. But I'm going to assume the judge did it for a reason. And this simply says, tell us the reason. And if a lot of judges have told the reason, this will not impact very much, except it will give us an answer to those who don't like what judges do.
Yeah. Well, I'm certainly in favor of judges making it clear on the record why they have either kept something out or let something in.
Okay.
And usually the lawyers make the argument. I mean, the objection leading, sustained, the record's clear why that question wasn't allowed.
But as we know in family court, pro se is what, 80%?
Yes, 85.
And they may not give a reason. They just say something.
Right. Yeah. That's the challenge of training new judges about how to deal with self-represented litigants, which is a large part of our training and procedural fairness.
Sure.
With all due respect, that bill is not before this committee. Could we,
No, it isn't, but the
Focus
subject
on-
is in terms of review, in terms of what they need. Should this
Okay.
become law? That's why I brought it up.
okay, go on.
If you've read the amendment become the bill, or if you would, I'd be happy to talk with you about it before it goes to the Senate,
Okay.
because there may be a way I can improve it when it goes to the Senate by making a suggestion as the chief sponsor.
Okay.
Thank you.
Sounds good.
Thank you.
Anything else?
If I may add,
Please.
going back just a beat to Judge King's offering of the blend, I think is the word you used. Whenever we think about adding new judges, we think about making sure that there's sufficient staffing to support those judges. So in addition to staff attorneys to work with the judges on orders, et cetera, making sure that our courts are staffed sufficiently to be able to get those orders out and process those cases, et cetera. So we've been incredibly grateful for the positions that the legislature has given us. I think whenever we're adding new judges, we just want to think about the ratio of judge to staff that would make the most sense for the weighted caseload to be able to make sure that those orders are getting out timely. That's the other piece of the equation related to timely orders and handling of cases.
Well, thank you for saying that, and I think that's a very good goal. But I think what we're dealing with here is recognition that as admirable as the goal is, we have not attained that goal of having enough, you use the word staff attorneys, and so I'll use that because I want to be more appropriate. I was using a more general term. We have seen that as a problem. And perhaps we're wrong. Perhaps having additional staff attorneys to begin to mirror what goes on in the other courts is not a desirable goal. But at this point, from our position, we think that you need more clerks, more staff attorneys to do what needs to be done. And if we're wrong, if you believe that the ratio that you have now is more than adequate and the cases would not move more efficiently and more appropriately if we added more staff attorneys, then tell us that we're wrong, because you're the experts and we respect that. But what we observe and what we have heard, truthfully, from employees of the court system, who, needless to say, do not want to be named, and understandably so, is that the workload for staff attorneys is such that it interferes with the smooth operation of the court.
Yes, and so perhaps I'm using terminology in a particular way, so maybe I can just articulate that, and then of course we would welcome whatever resources the legislature would be willing to provide. When we say staff attorney, there's a particular position of staff attorney that supports judges in doing that legal research, preparing some portions of briefs, et cetera. Those folks are central and then allocated to judges as there may be need, based on what judges around the state are handling. So we currently have 3 of those. Our weighted caseload indicates we need more of those. I think you've mentioned law clerks, which are generally assigned to a particular judge. That's the model in Supreme and Superior Court. So that's a law clerk to a judge, or perhaps a law clerk to 2 judges. So that's a more concentrated resource that may do many of the things that our staff attorney does, but does it for a smaller subset of judges. Clerks in our system are the court staff who in circuit court are not required to be attorneys. Those clerks manage the courts themselves. And so they manage both the staff, but also the schedules for judges, resource allocation within a court location, or sometimes more than one court location, depending on that management group. And then I've been using the term court staff to apply to all of the staff that work in the courts doing the case processing themselves. So those folks are not assisting the judges in terms of writing orders or doing that legal research, but doing the case processing that happens on the front end and the back end before a judge receives the case and after a judge is completed with the case. So those are the 4 sort of buckets that we've been talking about. I know this committee previously has mentioned court monitors as well, which in Superior Court are court staff that sit with the judge in the courtroom and handle the record, and keep track of evidence that may be coming in, et cetera. But those are distinctions in court staff based on role and title.
I thank you for that, and I very much appreciate it, and I do hope that you will understand that not one of us, well, maybe, and most of us sitting here do not presume to know everything we should know about how the court operates. So perhaps we are using terms that a layman might use that would mean something very different to you. I think a couple of times I've tried to use the very general term of support, leaving it not to me or to my colleagues in the legislature, but to you to figure out where that support is needed. So please understand that whether I say staff attorney or clerk or whatever else, my concern, and I believe the concern of my colleagues, and I haven't heard them disagree, is that there seems to be a problem despite all your goodwill and despite all your willingness to be appreciative of whatever the legislature chooses to give to the courts, that nonetheless, you as professionals with high standards could do a better job at what you're trying to do if you had the necessary, we're not talking about building an indoor swimming pool for you here, the necessary supports. And that's where we want you to know that we are concerned. We don't want to make your decisions for you. We need your guidance. We recognize the value of 3 independent branches. We're old-fashioned enough to believe in that. We don't want to overstep from the legislature to the judicial, but we think that we have enough evidence that may or may not stand up in a court of law, but does stand up in the legislative branch that you need additional help to do what we expect you to do. And we can say, well, we think you should have more X, Y, or Z, but you can tell us what you do need. And to hesitate is to really do a disservice to your branch, because without telling us, we can only guess. And why should we guess and give you the wrong supports when you know what we need? And it might be that you have procedures where, for example, you don't feel comfortable saying anything unless it's the Chief Justice who's saying it. Fine, then you're not going to say anything, and that is his loss and your loss. And that's my lecture for the morning, and I'm going to recognize the chair.
Would the weighted case study address some or all of Madam Chair's concerns?
The weighted caseload will tell you specifically what we need for judicial and staff resources. And when I say staff, I'm talking Heather's definition of staff, the worker bees in the courts. It also, I'm not sure that the National Center had dealt with the notion of staff attorneys as opposed to law clerks before, so it's not really clear on that, but I'll just want to take 2 minutes to explain the difference in why we go staff attorneys versus law clerk. Law clerk, and to me, which is the Supreme and Superior Court model, basically generally fresh out of law school lawyers who do a 2-year rotation, assist in research and writing, and then hopefully go on and get a good job in a firm, and then a new crop comes in. We have figured out in the circuit court that it's better to have permanent positions, because I believe that law clerks are probably reinventing the wheel every time a new crop comes in. You have a motor vehicle stop with a Fourth Amendment search issue, write me the order. That order has been written 100, 200, 300 times in the Superior Court. We have an orders bank. We have that order in our orders bank. The staff attorney can get that out and get it to the judge without redoing the research. So we don't need as many, because I think we've created some efficiencies, but we don't have enough. So I won't squander the opportunity. We would like additional staff attorney resources. I think the judges would welcome it, particularly in the family division. There's a lot of legal nuances to parenting and marital cases. The orders tend to be long. An order needs to be clear when it goes up to the Supreme Court so that the Supreme Court has a good record. I'll mention the court monitor issue just for one reason. I know the committee heard testimony that the judges somehow have control over the court recording equipment. I don't know how to turn the recording equipment on or off. I know there's a digital readout on my bench that tells me that it's running. We typically don't have anybody sitting with the record. In some courts, the court security officer literally turns it on and turns it off. In the Concord Probate Court, where I'm now sitting a couple days a week, there's not a staff person to go in there. I think we're going to turn the record on in the morning, and it's going to run all day, whether there's anyone in the courtroom or not, because we don't have the staff to be in the courtroom. We'll have to put up a sign to say, hey, we're recording in process. So if you're in the courtroom, be careful what you say about the judge or the person on the other side of your case. Court monitors are great. They sit at the recording equipment. They make contemporaneous notes. If there are spelling issues that come up in the trial, that can go with the record to the company that types up the transcript. When you get a transcript prepared out of the circuit court, there are no contemporaneous notes. The record's the record. We've had trials where the judge thought the record was running, and at the end there's an appeal, and lo and behold, there's no record because there was something wrong with the equipment. If you go to Superior Court, you'll see somebody at the recording equipment with headphones on, listening in real time to make sure all the microphones are working, and it gives you a much better record. But that was the 2007, 8, 9 budget. We basically eliminated our court monitor positions in favor of court assistants because we were trying to be frugal with the budget.
Follow-up? Follow-up is, would it be appropriate to ask your office to add to your sending us the weighted case thing with a 1 or 2 pager articulating this. In other words, if some of us are going to lobby our friends who are working on the next budget, the weighted case study thing will be helpful, but so will a 1 or 2 pager adding on to it the specifics that you've articulated. Would it be appropriate to ask you for that?
I would be happy to work on that with folks from the AOC and the Supreme Court and send something over to the committee if that's something that you would want. I mean, again, understanding that we're talking about the next budget cycle that
Right,
we'll be working on soon.
right.
I do want to be clear that while my colleague used the word lobbying, he really didn't mean lobbying. He meant working with our colleagues to give them the information necessary for them to make an informed decision.
I yield to what she said.
Understood. Every word has specific meanings.
I know.
Especially in this
Exactly.
building.
And court monitor meant something entirely different from what I thought it meant.
And I've never met a lobbyist in a lobby. I've only met them in a corridor. That's a discussion for another day.
At least not in the local bar.
One-
Your kind of bar, not the other kind of bar. Anything else?
One additional piece that isn't captured in the weighted caseload, because it's really a measure of how many court staff and judges are needed to handle the caseload itself, is it doesn't capture a training professional or it captures training time for those folks who are doing caseload work. But the time of a trainer isn't captured in that weighted caseload. And so, so that's not something that would be reflected in that report that you'll see. We do have one full-time dedicated circuit court staff person that's dedicated to staff training. And she's exceptional. She has certification from National Center for State Courts on education development. And that is a substantial task for one person. We have about 390 staff in the circuit court to be responsible for all of their training. And so if there were additional resources available, I think deploying some of those to create more of a training department or at least provide her some additional resources, staff time to work on materials, develop new curricula, et cetera, would be helpful.
Did you just raise your hand? Please.
To clarify further, the bill as amended, it's 475 or 499, it's one or the other. In terms of the judge noting the reason for ruling, it is only to objections to evidence being offered. It's not to any other objection. That's a narrowly construed ask.
That's pretty much a trial, right? I mean,
Okay.
a trial's about evidence. So that pretty much would cover everything from you may proceed to case submitted and everything in between.
Okay.
Okay.
Thank you.
Thank you. I am conscious of how many cases are not being heard because you're sitting here, and I worry about that, and I worry about your colleagues who have a lot of work. Is there anything else that you would like to share with us? Any of you would like to share with us?
I think the only other question that was in your email that we haven't talked about, and it's probably a quick hit, is the notion of judges conferring with each other about maybe separate issues ongoing in the same family. So you've got, it's not uncommon to have an abuse neglect case, a criminal case, maybe a landlord-tenant case, a guardianship. I mean, there can be a whole host of different cases involving one family going on at the same time. Hopefully they're all in the same jurisdiction, but they might not be. They might be on the line of, they live in this jurisdiction, but the kids are here because of placement issues. The Code of Judicial Conduct really prevents judges from conferring with each other about cases. What we have tried to do in a limited area, when a new guardianship or I think abuse neglect petition comes in, we have added language that says that the petitioner understands that the court or staff may refer to other related cases. And in our case management system, if there's a abuse neglect case going and there's a guardianship case, there should be a cross-reference in the case management system so the judge or staff knows that there's a related case. We try to make sure that the same judge has both cases to the extent we possibly can. I'm not sure if that's responsive to the issue that you asked, but it's not perfect. We can't do it in every situation, but that's the best case scenario.
Well, I think it is responsive, and I thank you. And of course, you're much younger than I am, but I hope by now you realize that the world is not perfect. We're just trying to get to be more perfect than we are now. This subcommittee is going to kind of try to write up where we are. And at some point in the next few months, but not immediately, because of the other responsibilities we have in our committees, the full committee will be called together by the chair of the full committee, Representative Pearson, and we will try to finalize the suggestions from the myriad subcommittees. While we don't anticipate at this moment calling this subcommittee together again, if you have anything you want to add or suggest or help inform us, we would very much appreciate it. And I hope that this report will be one that is not just a report that serves to permit people to vent, which is a helpful thing, but also to help make sure that you all can do a better job at what you're doing. And we thank you for that. And we thank you also today for taking the time to recognize that what goes on in the family court differs dramatically from what goes on really in the circuit court as a whole, the Superior Court, and of course, the Supreme Court. So that to the extent that decisions are made generally for the judicial branch, we have to recognize the differences within the judicial branch, or we're not doing the right thing.
I think it's no coincidence that tonight is the season opener of Law and Order. So I will be there with an adult beverage looking at Sam Watterson,
Okay.
and I encourage all my colleagues to do the same.
If they're not writing decisions.
Thank you very much for your time. We really appreciate it.
Thank you very much. We appreciate this, and all of you for coming. This is difficult, and nobody thinks what we're trying to do is easy, but we do look back at legislative attempts in the past that might have met needs at that time, but we saw that a somewhat different challenge this time. Thank you.
Just for public information, my desire as the chair of this subcommittee pointed out, when this subcommittee is finished up our work and the other one that Representative Katab heads does, we will have a committee of the whole. We will review the final two reports. We will tweak them. We will finalize our views on them. I've decided not to shut down the special committee. I've polled the membership. There's a few other issues that we think need to be addressed, but we know some of them are being addressed by legislation we're considering presently. Others have various committees or commissions around the state looking at those issues, and we did not see the need to have yet another group doing the same work. But we can't always predict the future. So if in June something pops up having to do with family court that none of us has anticipated, we can then reactivate the committee if we choose to. Other than that, we will just let it stay on hold until it sunsets the 1st of November. So there is an outside possibility we may crank up again, but we don't know that. So just for the record, thank
If
you.
we can help in any way, please let us know.
Appreciate that, sir.